Good morning and welcome to the Department of Health's pre-application webinar for our July 2019 request for applications for new alternative treatment centers. Today we're going to cover a number of things. First, we're just going to go through a quick introduction, talk about how we got here. We're going to go over an overview of the RFA, all the requirements, all the things that you all as potential applicants need to submit, an overview of the application form itself, and then we'll get into some of the frequently asked questions that we received in advance of this webinar. So this RFA represents the ongoing commitment of the Department of Health to expand access to medical cannabis here in the state of New Jersey. Thanks to reforms implemented over the last 18 months, we've seen the program grow to triple the size as when Governor Murphy took office in January 2018. As of today, we're over 51,000 patients, over 1,000 doctors enrolled to serve those patients, and over 2,000 caregivers. Some of the reforms that we put in place that have made this possible are adding 6 new conditions, 2 types of chronic pain, anxiety, Tourette's syndrome, migraine, as well as opioid use disorder, provided it's accompanied by medication-assisted therapy. We've cut fees in half for patients. It used to be $200, now it's only $100 to enroll. We've also expanded eligibility groups for discounted fees. Roughly 60% of patients in the program only pay $20 every 2 years to maintain enrollment. We've streamlined enrollment for patients, for caregivers, and for physicians. We've promulgated new rules to liberalize the program's requirements, and we've expanded the industry, announcing 6 new ATCs last December, which are in the process of opening up and expanding the current industry through the addition of satellite locations. The governor signed Jay Koenig's law on July 2nd, which will only continue to expand this industry and this program, making it easier for patients to sign up, making it easier for a healthcare practitioner to serve those patients, and reducing burdens on the industry. The Department of Health in this RFA is seeking new applicants to operate up to 24 alternative treatment centers. That's broken down in the following numbers per region. In the northern region, up to 8 alternative treatment centers, 2 with cultivation endorsements, 5 with dispensary endorsements, 1 vertically integrated permit. In the central region, up to 8, 2 cultivation endorsements, 5 dispensary endorsements, and 1 vertically integrated permit. And in the southern region, up to 7, 1 cultivation endorsement, 5 dispensary endorsements, and 1 vertically integrated permit. There will also be 1 vertically integrated permit awarded at large. The award will be determined based on score as well as overall location and patient enrollment at the time of award. In terms of applicant eligibility, both for-profit and nonprofit entities are eligible to apply for this RFA. Only applicants for vertically integrated permits are eligible to submit an application for more than 1 endorsement per region. Applicants cannot submit for both vertically integrated permits and individual endorsements. Applicants submitting for individual endorsements can submit applications for up to 3 endorsements, but they can't be in the same regions. So if you're submitting for a vertically integrated permit, that means that all of your applications for endorsements, your single application has to be in the same region. If you're submitting for multiple endorsements aside from the vertically integrated permits, you can only submit up to 1 application per region. No applicant's going to be awarded more than 1 permit pursuant to this RFA, and consistent with the changes associated with Jay Koenig's law, no applicant shall hold more than 1 cultivation endorsement, 1 manufacturing endorsement, and 1 dispensing endorsement as a result of the awards made pursuant to this RFA. An important note, current ATC permit holders, including awardees from December 2018, as well as associated entities with our current permit holders. These include entities that have management services agreements with them, major funders, etc., are not eligible to participate in this RFA. What do I mean by that? By not eligible, I mean not eligible, which includes management services agreements with potential applicants, funding that represents over 5% equity, intellectual property, any and all board representation, and any other significant involvement. Again, current ATC permit holders and associated entities and individuals are not eligible to participate in this RFA. The RFA was announced on Monday, July 1st. On Monday, July 15th, we released the forms associated with the RFA. Today, August 2nd, we're holding the pre-application webinar. Applications are due in roughly 3 weeks. The submission deadline for dispensary applications is August 21st at 3 p.m., and the submission deadline for cultivation and vertically integrated applications is August 22nd at 3 p.m. The review and award schedule beyond that will be determined based on the volume of applications that we receive. And related to this timeline and just more broadly, applicants should continue to monitor the department's website for any documents related to the application process or questions related to this webinar. The department has established 3 tiers of cultivation size for both the cultivation endorsements as well as vertically integrated permits. These are up to 5,000 square feet, 5,001 square feet to 20,000 square feet, and 20,001 square feet to 30,000 square feet. In terms of cultivation endorsements, we're seeking up to 1 cultivation endorsement in the 5,000 foot range, up to 2 cultivation endorsements in the 20,000 to 30,000 foot range, and up to 2 in the 5,000 to 20,000 foot range, for a maximum of up to 5 cultivation endorsements. The maximum initial canopy size is not to exceed 30,000 square feet as a result of this RFA. Vertically integrated applicants may choose any of the cultivation tiers. For the vertically integrated permit specifically, the department's going to seek to issue at least 1 vertically integrated permit in each region, and then the 1 at-large permit that I spoke about previously. Applicants seeking a vertically integrated permit shall seek to maintain all their operations under a single ATC entity within a single region. This is compliant with the provisions of NJAC 864-79. They can also have up to 2 locations. So you'll notice on the application form Part A, for vertically integrated applicants, they can notate a maximum of 2 separate locations, 1 for their cultivation and manufacturing operations and 1 for their dispensing operations, and all of those shall be in the same region. Related to the application itself, vertically integrated applicants only need to submit 1 Part A of the application. However, they need to submit 1 Part B for each endorsement being sought, and given that a vertically integrated permit is comprised of 3 different endorsements, 1 cultivation, 1 dispensing, and 1 manufacturing, they therefore need to submit 3 Part Bs for the application. For all applicants, RFA Part A comprises all of the entity information and mandatory information that we're seeking from applicants. These include things like legal name, status, and owners of the business entity, proposed location, proposed employees, investors and creditors, entities and persons with indirect authority or interest over the ATC, and floor plans and exterior renderings. For Part A, please consult the checklist that we've posted on our website for a list of all the required information that we expect to be attached to the form, as well as naming conventions for those files. Required documents should be attached directly to Part A for applicants that are submitting electronically. For submitting a paper application, you can just print them out along with Part A. We're looking for a high level of disclosure from applicants in this process. Specifically, we're asking applicants to disclose all persons or business entities having direct or indirect authority over the management or policies of the proposed ATC, every person or business entity having 5% or more ownership, whether direct or indirect, and whether the interest is in profits, land, or building, the identities of all creditors holding a security interest in the proposed ATC, and the identities of all employees, principals, officers, directors, owners, and board members, and whether or not they are associated with any other ATCs, including ventures in other states. If an entity has a parent company or affiliate that operates cannabis businesses and will be involved in the proposed ATC, either through management, intellectual property, real estate, or funding, then that parent company and/or affiliate must be disclosed in the application to operate an ATC, including disclosure of board members, principals, owners, and any other interested parties involved in the parent or affiliate. Failure to disclose parent companies, affiliates, and the individuals involved in their management, funding, and operation may result in disqualification from the application and/or permitting process. Related to the disclosure of these related entities, we're also asking for all contracts and term sheets, whether proposed or executed, related to management, intellectual property, real estate, equity in, or funding of a proposed ATC. All of this must be disclosed and submitted with the application. Failure to disclose and/or submit a contract or term sheet may result in an application being deemed non-responsive and will not be allowed to be introduced during the permitting process. Some key questions to highlight on Form Part A, where we're looking for this level of disclosure. Question 11, corporate structure. Question 12, history of the ATC entity. Question 17, licenses held in other states. Question 20, record of owners, principals, and other interested individuals. Question 22, contractors, landlords, and other contracted firms. Question 25, financial and management agreements. I'll note question 25 because previously I talked about the contracts associated with the management of the ATC. This is where applicants would attach or submit those arrangements. Applicants, in addition to Part A, are required to submit personal history disclosures for key individuals associated with the ATC entity. These are to be filled out by all owners, principals, partners, board members, directors, trustees, and officers of the ATC entity. And this includes individuals involved with the ATC entity via a parent, affiliate, or investor group. A general rule is if an individual is listed on question 20 on Part A, they should submit a PhD. The only exemption there really is if they're a passive investor with less than 5% equity in the ATC entity, in which case they do not need to fill out a personal history disclosure. For Part B, it's important to note a change from last year's process. There is no Part B form. Instead, applicants are directed to create a single PDF with responses to all the questions in Part B of the application. There is a page limit for Part B, 100 pages for each endorsement, and there are no exceptions or exemptions. For criterion 6 in the scoring, applicants shall only respond to the measure that is applicable to the endorsement being pursued. Vertically integrated applicants shall submit 3 Part Bs, 1 for each of the endorsements that make up the vertically integrated permit. Fees associated with this application process, pursuant to NJAC 864-65, as a condition of the department's consideration of an application submitted in response to this RFA, applicants shall submit a fee of $20,000 for each endorsement being sought. The applicant shall submit the fee with the application in the form of 2 checks payable to the Treasurer, State of New Jersey, one of which is for $2,000, the other of which is for $18,000 for each endorsement. If an application is unsuccessful, the department shall retain the $2,000 fee and shall destroy the other check or checks for $18,000. Important note, applicants shall not submit certified or cashier's checks, as we will not be returning the $18,000 checks for unsuccessful applicants. They will be destroyed. For submission, applicants have 3 options. We recommend online. We've created forms for online submission. It's the easiest to fill out the forms that way and submit just via the internet. Although we will also accept in-person submissions, and these could be either via mail or courier or hand delivery. Related to the submission, whether doing it electronically or in person, applicants assume sole responsibility for the complete effort involved in application submission, including timely delivery. Allow plenty of time for the application submission process, as applications received after the application period closes will not be considered. All applications must be received in accordance with the timeline set forth in the RFA. So that means there's a hard cutoff for dispensaries at 3 p.m. on August 21st, and a hard cutoff for vertically integrated and cultivation applications August 22nd at 3 p.m. Applications may be submitted online at the link provided here. There are different forms for each type of endorsement or type of permit being sought. So there's a form for cultivation endorsements, a form for dispensary endorsements, and a form for vertically integrated permits. Important to note, on each form, there's only an option to submit a Part B for the endorsement associated with that form. So there's only 1 Part B associated with the cultivation form, only 1 Part B associated with the dispensary form, but 3 Part Bs associated with the vertically integrated form. If applicants are submitting online, they will still have to submit a hard copy of 2 things. They will need to submit a hard copy of the cover sheet, which are the affidavits, waivers, and releases that must be signed on behalf of the ATC entity, as well as the actual checks for the application process. And those can be submitted via courier, mail, or in person on those submission deadline days. Hard copy submissions shall be submitted to the department at the following addresses. Please allow sufficient time for delivery. They must be received by department staff by the deadlines. If applicants are submitting for paper, they have to submit 1 complete paper copy marked as original, containing the physical signatures on all forms and the required fees. Again, for those submitting electronically, they only need to submit the cover sheet, which is the affidavits, waivers, and releases with those original signatures and the required fees. So in total, each application will be comprised of the following: the cover sheet, which is the signed affidavit, waiver, and release; application Part A with all associated attachments; application Part B, which has a 100-page limit per endorsement; and the fees indicated in the RFA. Applicants may also submit nothing else. That's it: Part A, Part B, and the cover sheet, as well as the fees. In terms of required signatures, there's 3 places where applicants will need to actually sign these documents: the affidavit, waiver, and release, Part A, which can be signed electronically if submitted electronically, or a hard copy signature if submitted in hard copy, and the personal history disclosures, which have to be signed by the individuals filling them out. In terms of exemptions from the 100-page limit in Part B, there are none. This is a change from last time where we provided for some exemptions to the page limit. In this application process, there are no exemptions. Applicants must stay within the 100-page limit. Anything above the 100-page limit will not be reviewed and could risk disqualification. For the application evaluation, there are a set of scored criteria, which you can see by consulting the RFA. The information is going to be judged by a selection committee according to weights. It's a 300-point scale per permit endorsement. Once received, the applications will be reviewed for completeness and then released to the selection committee. Just to run through the scoring, they're broken down into what is in our rules, and they are ability to meet overall health and safety needs of qualified patients and safety of the public, which is broken down into 3 different measures: a security plan, an environmental impact plan, and a quality control and quality assurance plan, each worth 10 points. Then there's history of compliance with policies and regulations governing government-regulated marijuana programs. Here we're looking for an explanation of the background of principal board members and owners, either their experience in the cannabis industry or other highly regulated industries like the cannabis industry. This is worth 20 points. Next is ability and experience of the applicant in ensuring an adequate supply of marijuana. Here we're looking for a financing plan, which will be judged on things like transparency and suitability. We're also looking at community support and participation, specifically ties to the local community and how long individuals associated with the ATC entity have resided in the state of New Jersey. Next is the ability to provide appropriate research data. Here, we are looking for actual published research contributions, actual cited original work, and that is worth 10 points. The bulk of the application is the experience in cultivating, manufacturing, or dispensing marijuana in compliance with government-related marijuana programs, which include either a cultivation plan, manufacturing plan, or a dispensing plan, depending on which endorsement or permit being sought. Cultivation plans will only be submitted by cultivators and vertically integrated applications, manufacturing plans in this opportunity only by vertically integrated applications, and dispensary plans only by dispensaries and vertically integrated applications. Applicants shall only respond to the applicable measures for the application being submitted. Next is the cultivation plan. Here, applicants will be scored on their overall practices, policies, and procedures, experience and education in botany, horticulture, phytochemistry, and the application of those sciences in the cultivation of medical cannabis, methods to control insects and pests that do not include the application of pesticides, as pesticides are not allowed in the medicinal marijuana program, methods to prevent, minimize, and test for plant disease and other contamination, and methods and practices related to odor mitigation, sanitation and airflow, and employee safety in cultivation environments. Each of these will be worth 20 points, adding up to 100 points total for the cultivation plan. Applicants for vertically integrated permits will submit a Part B that includes a manufacturing plan. This includes overall practices, policies, and procedures, experience and education in biochemistry, laboratory science, and engineering, and cannabinoid extraction methods. Description of products that the applicant intends to manufacture, along with ingredients and administration methods. Methods to prevent and test for contamination in those products, and health and safety standards for their lab employees. Each of these will be worth 20 points for a total of 100 points for the manufacturing plan. Applicants for dispensary endorsements will submit a dispensary plan. This includes overall practices, policies, and procedures related to dispensing medical cannabis, experience and education in the treatment of patients with qualifying health conditions, patient education and counseling methods, employee education procedures for their patient-facing staff members, plans to recruit and educate healthcare practitioners about the dispensing of medical cannabis to qualified patients, and explanation of how the proposed dispensary location expands access to patients and caregivers. That's 6 measures within the dispensary plan. The first 2 are worth 20 points. The rest are worth 15 points for a total of 100 points. Finally, the last 100 points associated with the application is the workforce and job creation plan. This includes a labor peace agreement, a labor compliance plan, whether or not the applicant has minority-owned, women-owned, or veteran-owned business certifications in the state of New Jersey, and a workforce and job creation plan. A quick note about the labor peace agreement. What we're looking for is a signed labor peace agreement that includes provisions to ensure that the cultivation, manufacturing, and/or dispensing of medical cannabis will not be disrupted by labor-related disputes. If an applicant does not provide a labor peace agreement, that will result in a score of 0 for this measure. For the minority-owned, women-owned, or veteran-owned business certifications, we're looking for a copy of the certification or certifications issued by the Department of the Treasury Division of Revenue, which verifies MBE, WBE certification or VOB certification. Applicants can also supply evidence that they would otherwise meet those requirements once generating revenue or once operating in the state. Applicants with a certification or certifications will receive the full 30 points. Applicants that provide evidence but not the actual certification will receive partial credit, but only dependent on the strength of that evidence. Important to note, the selection committee will be directed to look at related entities for this measure. So if there's a parent company, we'll want to know information about that parent company. While the New Jersey-based entity will get the certification, we'll also want to have a look at the makeup of parent and affiliate companies related to these measures. In the determination of whether an applicant passes or fails a particular requirement in the mandatory section, which is Part A, the department is going to review the information for completeness and truthfulness. If applicants don't submit complete or truthful information, they may be disqualified. Additionally, applicants may be disqualified if the information provided raises significant concerns as to their ability to comply with program rules, regulations, and statutes. If the application is found complete, then it's going to be moved on to a selection committee. The selection committee is going to be comprised of individuals with varying expertise related to the applications and the scoring. Scorers will score individually, but their collective score will make up the applicant's final scores. The total final score for each endorsement sought will be out of 300 points. An important note on public disclosure. Items submitted pursuant to this RFA are generally subject to public release pursuant to the New Jersey Open Public Records Act and/or the common law. Proprietary and other types of information may be exempt from public disclosure, including, but not limited to, personally identifiable information, confidential information, information that would provide a competitive advantage or disadvantage. Once awards are made, winning applications will be redacted according to some of the information that I just described and then released to the public, but they will not be released before awards are made. Now we're going to move on to an overview of Form Part A. The primary form is Form Part A. There is no Part B form for this RFA. There's only a Part A form as well as personal history disclosure. For the Part A form, it's a fillable PDF. Applicants must know that they should fill this out in Adobe Reader. If you don't have Adobe Reader, you can download it from the link on our website. Please do not fill out the form in your web browser, as it will not fill out correctly and it will not save correctly. All the required information related to Part A is included within this form. I want to go over some key differences as well as some key buttons and functionality in the form that applicants will need to be aware of. The first thing to note is that for question 5A and 5B, there's an opportunity for applicants to input 2 separate locations. Only vertically integrated permits will input those 2 separate locations. One is for cultivation and manufacturing, and the other is for dispensing. If you're submitting an application for a cultivation endorsement or dispensary endorsement, you'll only fill out one site in that section. I also want to call your attention to some buttons on this form. You'll notice attach buttons throughout the form. You can click those buttons, which will allow you to attach files to the form itself. It will open up a box to allow you to select the file you wish to attach, and then you can attach it directly into the form. To see the files that you have attached, you can click the paperclip, which is on the left side of the form, and that will open the attachments pane where you can review all of the attachments that have been attached to the form itself. I'll also note that on several questions, there's a button where applicants can click to add more space. What this does is it adds an extra page if an applicant needs more space to fill out that particular question. Some places where you might need this: question 12, the history of the ATC entity; question 20, all the board members, officers, investors, etc. Question 21, staff members. All of these and other questions have this button that allow you to add additional pages should you need extra room. Question 13A has changed from the July 2018 RFA. You'll note that it's customized for this particular opportunity. Applicants will choose not only the region they intend to apply in, but also what endorsement they're seeking or permit. They can choose between cultivation, dispensing, and vertically integrated. And if they are submitting an application for a vertically integrated permit or a cultivation endorsement, they are directed to choose what size canopy tier they are applying under, up to 30,000 square feet, up to 20,000 square feet, or up to 5,000 square feet. I want to call potential applicants' attention to question 20 on the form, because as previously noted, this is where we want applicants to have a high level of disclosure. They should fill in individuals who are owners, principals, partners, investors, members, board members, directors, trustees, and officers of the ATC entity, but also of entities involved in the day-to-day operations, funding, or intellectual property of the proposed ATC entity. This is one question where you can click to add more space should you need additional pages. Also related to question 20, I want to call your attention to the attach buttons all the way to the right of the form. It says attach PhD to. This is where each individual listed in question 20, provided they are not an investor with less than 5% interest, will attach a PhD to. The PhD can be downloaded on the department's website and filled out by each individual associated with the ATC entity or related entities. I also want to call attention to question 25A, because in the RFA, we ask applicants to disclose any signed or potential contracts for management services agreements or other contracts related to the day-to-day operations of the ATC entity. Question 25A is where applicants would attach those contracts or potential contracts. Now I'm going to cover how to sign Form Part A. Page 14, which is the signature page, should be completed by an individual who's authorized to legally sign on behalf of the ATC entity. That individual will fill in their name, title, and position, the name of the ATC entity, and their signature, which can either be submitted in paper or electronic form. The department recommends submitting electronically. You can sign and endorse it electronically in the PDF, and then you could submit online using one of our online forms. To do this, you'll notice there's a button on the bottom of page 14 which says Endorse Part 1. You will click that button, which will bring up a prompt asking you to confirm that you are ready to endorse the application. Once you digitally sign the application, you can't go back and edit it. So don't do this until you are done filling out the application. You're going to type in yes in all capital letters into that box if you are ready to sign, and then click OK. A pop-up box will now come up and tell you the application is ready to endorse. Click OK, and a signature box will appear. To go ahead and sign the application, applicants should then click that signature box. Once again, they will be prompted to confirm that they are ready to digitally endorse the application, which will make it ready for submission. Again, once you do this, you cannot edit Part A, so please do not do this before you are ready to submit. Applicants will then type yes to continue. Another pop-up box will show up that says the application is being signed electronically. A box will pop up with your digital signature. Applicants, prior to this process, will need to create an Adobe ID in order to sign the form electronically. If you have an Adobe ID created, the signature box will pop up and you will click Sign, which will apply your digital signature to the form itself along with a timestamp. At the end of the signing, applicants will be prompted to save the file in its completed form. Click Save, and then you could submit the file on our website using the form that's appropriate to the type of application you're submitting. On our website, we have 3 types. There's one for cultivation endorsement applications, one for dispensary endorsement applications, and one for vertically integrated permit applications. In addition to submitting Part A, you will also submit a Part B, which is not in a form, but is rather one single PDF created by the applicant themselves. Related to the attach buttons found throughout Form Part A, I want to call potential applicants' attention to the application checklist, which is posted on the department's website. This includes suggested naming conventions for each required attachment that is a part of Form Part A. Please refer to this checklist on how to name the files and which attachments are necessary and required as part of this application process. Now we're going to move on to talk about some frequently asked questions. First, the Part B form. Where is the form? Last time we had an RFA, there was a Part A and a Part B form, as well as personal history disclosures. For this round, we streamlined the application process, and there is no Part B form. The Part B form, or Part B, is to be created by the applicant as a single PDF, no longer than 100 pages. It should be clearly marked for headings and subheadings for each criterion and measure that the applicant is responding to, and should be uploaded as one file. I want to touch on application fees. In the rules for the medicinal marijuana program, it states that as a condition of department consideration of an application submitted in response to a request for applications, applicants shall submit a fee of $20,000 for each endorsement sought in the application. This is not entirely clear in the RFA notice, so we will be posting a redlined edited RFA notice today, which will explain exactly what fees are due for applicants. Each applicant shall submit a fee for each endorsement sought with the application in the form of 2 checks payable to the Treasurer, State of New Jersey, one of which is for $2,000, which is non-refundable, the other of which is for $18,000, which will only be cashed in the event of an award. For vertically integrated permit applications, applicants shall submit a total of $60,000. 3 checks for $2,000, one for each endorsement being sought, 3 checks for $18,000, one for each endorsement being sought. For cultivation or dispensary only applications, applicants shall submit $20,000 per application for each endorsement. That's 1 check for $2,000 and 1 check for $18,000. As a reminder, applicants can submit no more than 1 vertically integrated permit application, no more than 1 cultivation endorsement application, and no more than 3 total endorsement applications, and only 1 application per region. So how does that break down? That breaks down that if you are submitting an application for a vertically integrated permit, you can only submit 1 application, and it all has to be in the same region. If you're submitting for only cultivating or dispensing endorsements individually, you can submit up to 3 applications total, but only 1 per region, and you can only submit 1 cultivation endorsement application. That means that you can either submit up to 3 dispensary endorsement applications, 1 in each region, or 1 cultivation endorsement application plus 2 dispensary endorsement applications. As noted in the RFA, applicants will only receive 1 permit as a result of this awards associated with this RFA. That means that even though you can submit up to 3 individual endorsements in separate regions, applicants will only be eligible to receive 1. The exception is if you're submitting for a vertically integrated permit, in which case you may receive 3 endorsements as part of that application, but all will be in the same region. So that means that entities and individuals may seek up to 3 total permit endorsements as part of this RFA, broken down: 1 vertically integrated permit, which equals 3 permanent endorsements, or up to 3 applications for individual endorsements. However, they must be in separate region, and applicants can only apply for 1 cultivation endorsement total. So that means if not applying for a vertically integrated permit, applicants can apply for either up to 3 dispensary endorsements, 1 in each region, or 1 cultivation endorsement and up to 2 dispensary endorsements, each in separate regions. For vertically integrated applicants, they may only submit 1 application, as that application constitutes 3 permanent endorsements. Submitting more applications than an applicant is eligible to submit may result in disqualification of all applications. We've received some questions on locations. In the case of vertically integrated permits, this RFA is for a maximum of 2 locations, 1 for cultivation and manufacturing and 1 for dispensing. Those functions can also be co-located, in which case the application should be limited to 1 proposed location. You'll note on the form that there's an opportunity for applicants to enter in 2 locations, and it notes that's for vertically integrated applications only. For cultivation and dispensary applicants, each application shall be for a single location within the region. Please refer to NJAC 864-79 for guidance on the operation of a vertically integrated ATC. For municipal approval, the department is simply looking for some form of documentation that the municipal government is in favor of an alternative treatment center operating within that particular jurisdiction. Final zoning approval is not required in advance of the submission deadline. However, for local ordinances, the department is also looking for documentation that the proposed ATC is in compliance with local codes and ordinances. So while zoning approval is not necessary, we do want to see a map or documentation of the ATC at its proposed location being in compliance with local ordinances. Note that NJAC 864-13.6 stipulates that ATCs shall not be located within a drug-free school zone, so please consult with the municipality that you're seeking to locate within to ensure that your location is not located within a drug-free school zone. We received a lot of questions about Part A, question 20. I'll note that owners and investors with an interest of less than 5% do not need to be listed, nor do they need to fill out a personal history disclosure as part of the application process. If there's an investment fund or company in which no owner or investor has an interest of more than 5%, including publicly traded companies, but in total has more than a 5% stake in an applicant, then the primary decision makers for that fund and company should be included and fill out the personal history disclosure. I'll note that if there is an investor with less than 5% interest in the proposed ATC, but they have a decision-making role, they will need to fill out a personal history disclosure. For site control, meaning that an applicant has possession of the site at which they intend to locate, we will accept conditional letters of agreement or leases for this requirement. So you don't need an actual signed lease, you don't actually need to own the property for the application. We just need to know that you have exclusive rights to that property. A lease or a purchase can be executed quickly if an award is made. For cultivation endorsements and vertically integrated permits, you'll note in the RFA that we define canopy, and we limit canopy to certain tiers of size. I'll note that canopy means the total area in square feet in which an ATC is authorized by the department to cultivate medical cannabis in accordance with statutes and rules. However, for the purposes of this RFA, canopy shall not include areas used exclusively for harvesting, labeling, or storing of medical cannabis. On Form Part A and in the RFA, you'll note that there's the inclusion of a medical advisory board. Pursuant to statutory changes made on July 2nd, 2019, an ATC may have a medical advisory board. Therefore, for this RFA, medical advisory boards are optional, but if included, they must be disclosed on Part A. We've received a number of questions about residency requirements in this RFA. I want to state that there is no requirement in this RFA that applicants be New Jersey residents or those involved in applicant entities. However, applicants will be judged on ties to the local community through a history of residency, which will be scored as part of Criterion 4, Measure 1. When looking at proof of residency, a driver's license may be accepted as one proof of residency. Applicants are instructed to use their best judgment in the preparation of applications. Please refer to NJAC 864-1.1 for some other types of documents that the department routinely accepts to prove residency. In terms of the number of applications that applicants are eligible to submit, as stated previously, current ATC permit holders, including awardees from December 2018, are not eligible to participate in this RFA. That means they are eligible to submit 0 applications and be party to 0 applications. Being party to an application includes, but is not limited to, being a funder or a lender, entities with management services contracts, or other contracts related to day-to-day operations of the ATC or intellectual property, and any individual with decision-making authority or over 5% interest in an ATC or related entity. Silent partners cannot be included in this application. We want disclosure of every individual and every entity involved in the application process and involved in the proposed ATC. All individuals and entities must be disclosed. Failure to disclose may result in disqualification, either from the application process or in the permitting process should an ATC applicant receive an award. The department expects a high degree of transparency and disclosure from all applicants in this process. We've received a number of questions about requirements from the July 2018 RFA and how those apply to this RFA. Please note that each RFA stands on its own. Applicants should consult the requirements set forth in this RFA to inform and guide the preparation and submission of their applications. In this RFA, we've outlined many reasons why an application could potentially be rejected. Please refer to the RFA notice and this list for many of those reasons. For those submitting in person, which should be every applicant submitting at least part of their application in person, please use the following address for GPS: 369 South Warren Street, Trenton, New Jersey, 08608. The building looks like this. So before I go, I just wanted to provide applicants with notice about an important event happening on August 21st at the Trenton War Memorial, particularly for those of you who are submitting dispensary endorsements on that day. The Department of Health is hosting a harm reduction workshop at the Trenton War Memorial. As many of you know, earlier this year we added opioid use disorder as a condition available for treatment with medical cannabis. That's because we believe that we need to use every tool in our toolbox to address the opioid crisis. At this workshop, applicants for ATCs as well as other interested stakeholders can learn about the state's harm reduction efforts, learn about how to get involved with the Department of Health's efforts, and other collaborative state agencies. Thank you for viewing today's pre-application webinar. Please continue to monitor our website for future developments related to the RFA.